Good afternoon, dear ladies and gentlemen, dear colleagues. Today is, if I'm not mistaken, the 19th of December 2024, so it's very close to Christmas. It's 3 o'clock in the afternoon, and I'm very happy to introduce Dr. Gizem Gültekin-Várkonyi to you, who is a legal scholar at the University of Szeged, Faculty of Law and Political Sciences in Hungary. We met quite recently in Brno because there is a very nice international cyber law conference in Brno each year, which is called Cyber Law. If you want to Google it, I will also put the link into the show notes. Very nice, very big conference, and Gizem and me were there, and we talked about what we are doing. And I then also learned that she recently published a paper that is very interesting to what we are doing here, and I read that paper with very, very big interest. Here you see, if you're watching this, you see that it's published in the Internet Policy Review quite recently. So the publishing date that is mentioned here is the 30th of September, so very, very short time since then. And it's a rather lengthy article. So here's the full text. The full text is freely available. It's roughly about 35 pages, if you take the reference with you as well. 35 pages about a very, very recent and important and critical topic, which is about facial recognition in law enforcement under European legislation. And European legislation is primarily GDPR, the Data Protection Law Enforcement Directive, and the AI Act, obviously. And I read it with a lot of interest, and I learned a lot out of it, and I thought that it would be a good idea to share this knowledge now with all of you. So Gizem, thank you so much for being here. First, obvious question, what is this paper about? Second question, not that obvious perhaps, why did you write it?
Thank you so much for having me today, very afternoon of the 19th of December, as you said. And I would like to take this opportunity, first of all, to wish everybody a very, very Merry Christmas and a very Happy New Year. It's a great closing event for me, and I'm really happy to be here with you today. What the paper is about, actually, it's a kind of 2-3 years old of project in my mind that I was working on. I'm primarily focusing on data processing and personal data processing collection issues in technology. I actually wrote my PhD on social household robots and its interaction with the GDPR. Right, everything is actually about the personal data that we are processing, collecting in these technologies. And I was very interested in whether the current law is really in compliance with the technology that is being offered to us, to the individual, first of all, and to the public, actually, in a larger sense. Because all the technology comes with all advantages and disadvantages. And as we have seen in the AI Act and also in the GDPR as well, we have this approach that is referring to the risk management. And I was very interested in the facial recognition technologies because it's becoming more and more tried and implemented, practiced in a larger sense, in public level. I've heard about, for example, in Hamburg, about a couple of months ago, there was a trial on trying the facial recognition technologies in a real-time manner. And in the past, in France, in Italy, in Sweden, for example, at the high schools, there were some attempts to use facial recognition technologies, in a sense that it could be useful actually for not just for the law enforcement authorities, but also for example, in the high schools, whether the students was present or not, to verify the presence of the students as well. So this paper is actually diving very deeply into the question of whether the facial recognition technologies can really ensure that it is being used for public safety or public security purposes. And my very soon answer would be that there is no evidence and there is no clear answer on that. So I can't really tell you that whether the facial recognition technologies can boost public trust by ensuring security or vice versa. And it is actually, my findings are actually in line with the literature in this field as well. But what I was really trying to highlight in my article is that then what are the risks that we should be aware of, and how the law is approaching all these risks, whether they can handle or they can make it a little bit more complicated. All in all, what I just realized is that actually it's the law enforcement authorities that would be benefiting from all these technologies at the end of the day, and they might be a little bit unaware of all these risks, and the law might be a bit weaker in this sense. So I was trying to highlight the very certain points that can raise awareness on these topics, on these debates, and on these risks as well. So maybe if there is a plan in the future for any of the law enforcement authorities to be implementing facial recognition technologies, they can be using some of the tools that the law is enabling us, such as data protection impact assessment, or for the AI Act now we have the fundamental rights impact assessment, together with the integration of the quality management system, and so on and so on. So all these risks, what I was trying to highlight in my paper, are for actually mitigating in a sense that the law is enabling us some tools such as these impact assessments. So in the beginning of my paper, I was trying to identify these technologies, or what they really are. I couldn't really find any unified term or unified definition on this technology, facial recognition technologies, but I know what functionalities they can be used for, or what purposes they could be used for. These purposes are very broadly for authentication, that we might be using these authentication enabled technologies, for example, in our phones, that we can unlock our phones with our face, fingerprints, or voices. That is called actually one-to-one method. So there is one data that is matching with another data in the database, very, very briefly. The other purpose is that the identification purposes, that is a query on the well-known database, that our face information is queried into the database, and whether this face is matching with the other data that is available on the database, that is called one-to-many functionality or technique. And there is the many-to-many, so-called many-to-many technique that is actually might be causing, in a very broader sense, surveillance, because it is actually, you can imagine in some of the sci-fi films or episodes of some of the well-known series, that people are people are walking on the street and their faces are being captured very autonomously, and being identified in another autonomous database spontaneously. Of course, this is a bit a dystopian future, I would say, but it's not unreal, based on all those examples that I was identifying. And of course, we know these kind of technologies are being implemented in China, but luckily we are here in Europe, and I don't think that we will ever have such implementations in the close future, at least in Europe. So these are some of the technical background that was exciting me actually to write this article, and I was trying to find out whether these technologies are having some space in the legislation, especially in GDPR and AI Act. Right now, we all are in the sense that the legislation is actually technologically neutral. But according to my analysis and my opinion as well, in this case, my humble opinion, maybe we are missing the point in the sense that this technology neutrality doesn't really help us, because all the technology comes with its own costs and with its own risks. I don't really mean here that we should generate more and more law, because I just checked the digital policy of the EU, and there is already around 50 legislation pieces that are connecting to each other. So I'm not really here suggesting that we should generate more law, but the interpretation will help us in a sense that we can integrate all these technology-specific risks as well. I was trying to actually, another side of my perspective was to try to identify or define what facial recognition technology is. That I found out that there's a clear connection and a very strong connection between the biometric data and these technologies. And biometric data, as we all know, that is identified or defined in the GDPR and in the AI Act as well. So it's a sensitive data as well, right? It can actually help any of the data processor actually to find out psychological, physical, or behavioral information on the individual or even a group we can imagine. So definitely the FRT has its space in the law, in the EU's AI Act and the GDPR. And what this specific technology is creating risks in practice and in according to law is that I was actually using the same titles, same risk titles for both GDPR analysis and for the AI Act analysis. And I started with the identification of the general violence of general purpose or general rules, for example, the data minimization rule. For the GDPR part, I was actually trying to find out whether Article 5 of the data minimization rule is under threat if we really use these FRTs in a common spaces. I found out the Italian Data Protection Authority actually penalized a Clearview AI tool that is being used in Europe as well and in the US as well for facial recognition technologies and for actually predictive policing reasons. The Italian Garante already penalized this tool, but it's actually being still used in a broader level, even I would say. So whether this data minimization rule would be under threat, and definitely yes. We can imagine just on the street there are some CCTV capturing our moves, capturing us, capture our face, not maybe in a daily level, but even if we pass the street that is being recorded by such CCTV, it's a kind of data processing, I would say. If it's being referred, of course, by the law enforcement authority, it is definitely data processing. But even capturing, keeping this data is also a kind of data processing. So being under surveillance for 025 is a kind of ethically not in line with the data minimization rule. Another example that I found in the literature is that it can also cause some threats for exercising political rights, for example, right to peacefully protest. And out of the EU, there are some examples in London, in England as well, that some of the protests were actually captured by CCTV or other kind of video surveillance cameras, and FRT technologies are being implemented without any further introduction, any transparency rules, and any consent actually, which is under very big threat. Under normal circumstances, if the FRT is being implemented to a very specific point, with a very specific reason, it might be allowed according to law, but this kind of very general use of these technologies without being specific to the reason, to purpose limitation rule. In this case, I will be integrating myself there. It is not allowed and it shouldn't be allowed. However, the practices are showing us vice versa. In this sense, the data aggregation we should actually also be talking about. It's not just our video data that is being captured and being processed in the facial recognition technologies, but our pictures, voices, and etc. that is defined as biometric data. And usually this data is used both as a training data and as an output. In here, the consent and purpose limitation rules are also under threat. They are being risked because if it is the private company which is developing these kind of technologies, definitely they need individuals' consent to do so. If we post our picture, for example, on Facebook or somewhere else, Facebook is dead, right? It's Meta, sorry. And if the company is planning to process that data, they should definitely ask for our consent. But maybe referring back to the Clearview AI example, their facial recognition technology tool did not really ask for any consent of any individual. So it's just, a bunch of data that is being collected and processed by the company and is being now offered to the law enforcement authorities for predictive policing and other types of risk recidivism of, for example, purposes. So this is also highlighting the fact in this sense that the purpose limitation rule also might be under threat, and it can really cause the real function creep. I'm looking down because I have some notes anyway, even though I wrote the article.
Don't
It's
worry, it's
sometimes
all
hard
good,
to
all good. Yeah,
just to, I would like to highlight the most important parts because
sure.
it was a very big project for me. So I just would
Go
like
ahead,
to also
Gizem.
check
All
my
good,
notes.
all good. Please look down and go ahead, please. Go ahead.
All right. And before the final of the under the GDPR assessment, risk assessment, I would like to highlight the fact that the data accuracy issue that is referred under the GDPR and the technical term data accuracy, system accuracy actually are not the same. So for us in the GDPR, the data should be up to date. It should be current data. It should be processed in an accurate manner. And if it's not, the people actually have a right to put this data in an accurate level. So how it should be in the facial recognition technologies if they are operating with AI systems? For example, should we individuals go and ask for the law enforcement authority to update their database because we don't really look like that anymore? Or our past criminal records are not accurate anymore. So how can we really know that the law enforcement authorities have that data and they are being processed under such technologies like FRTs? So it's really hard to understand in practice how the GDPR should be enacted on FRTs used by law enforcement authorities. That is referring to data accuracy point of view. As I said, the data is both used for the training and for as an output data. And if the system is working with a feedback mechanism that the output can be refed to the system as a training data, which could be also used as the term of reinforcement learning, then it makes it a bit harder, this practice in this sense. I also would like to highlight here that in the GDPR, maybe it's not very clear, but also in the AIX, we can find some interpretation in that the place of fake images. So what if the company who created the FRT used some fake images to train its algorithm? It makes the things harder to understand and to interpret, and it actually directly affects the accuracy, the system accuracy. So the accuracy of the output in this sense and the accuracy of the data in the GDPR are not exactly the same in the technical and practical level, and also in the legislative level. Finally, specific to the GDPR, I was also highlighting that in the administrative challenges that the law enforcement authorities could face with, for example, the technical knowledge that the police officer who will be using these FRTs to assess people's I wouldn't really like to say criminality, but any of the purposes that I earlier highlighted, whether they are able to interpret these accuracy levels in a right manner. It's also bringing us the responsibility question, because if anything goes wrong, we will look for someone responsible. But since all these FRT type of technologies are being outsourced by the law enforcement authorities from companies, it makes very hard to understand who actually really is the responsible person. Luckily, in this sense, we have this AI literacy framework that is being introduced by the AI Act. While I'm not really sure about its details yet, because we don't have any guidelines, we don't have anything right now in our hands to understand this framework, but it might really help us to mitigate this technical level of understanding and in practice solutions. So this part was the identification of the risk specific to GDPR on facial recognition technologies. And with the same titles, I will go on with my analysis on the AI Act. Actually, as I just highlighted, there is no definition of the facial recognition technologies in law. And in this sense, the AI Act actually complicates this definition challenges further, because it introduces the definition of biometric data, which is actually exactly the same in the GDPR, and that's fine. That's quite understandable. But then we have biometric identification, biometric verification, post-biometric remote systems, real-time biometric remote system, and etc., many new terms. And I called it actually in the article as the term salad with no taste. None of them is actually referring to the facial recognition technology itself. What could be wrong with this? Actually, they are all related, but as I highlighted in the GDPR section, the facial recognition technologies have its own risks in this sense. And this actually makes us to understand even harder to see which law to be applied. Because if we call it as biometric data only, maybe we will be interpreting the GDPR, but maybe not, because if it is used as a purpose of another law enforcement concept, and maybe it is law enforcement directive, but if not none of them, then maybe we will be referring to the AI Act. So it's really hard to see from the beginning, if we have a case, which law to be applied. I just referred in the beginning that the EU's digital policy is quite large. We have also the AI liability directive and all the other directives and regulations. It will make very hard to understand which law is to be applied in a specific case. So once we define which law is being applied, then we can maybe find what purpose is fitting into. Because I'm now referring back to the purpose limitation issue, even though we are talking about law enforcement authorities and their actions are identified by law clearly. For example, I found in the Hungarian law, because there's a kind of facial recognition technology being implemented in Hungary, which is really out of many-to-many technique, or not even one-to-many, I would say. So it's very infant level. But when I checked the law, I just realized that the purposes, so the areas that the facial recognition technology could be implemented, is quite large. So actually everything and nothing at all. Once it is being implemented, we can see in the law there is a very broad interpretation possibility in at least in Hungarian law, and I don't really think that it is very different in the Turkish law, because I know a little bit of the Turkish law enforcement law legislation in this sense. So we all know that in the AI Act, especially for the real-time biometric data processing systems, there is an exemption or exception for the law enforcement use, and this exemption can actually cause some different implementations specific to the member states. Actually, this was already brought up to the European Parliament, and European Parliament wanted to entirely ban the facial recognition technologies or biometric data processing applications entirely. But what a surprise, France, Germany, and Italy actually said that if there is an entire ban, then we are not really giving our positive vote for the law. Germany and France probably were against, because they have some traditional security problems, issues that they have to deal with. And for Italy, I think that they have one of the biggest biometric data processing companies in their country, so they didn't really want to kill the innovation in this sense. So the member states some of the member states had their own interest in this case. And in the end, we can see that in the AI Act, there are some exceptional cases that the real-time biometric data processing systems can be allowed. And with this spirit in our hand, we can also see that the lawmaker actually, they were trying to find out a solution in between the public security, public interest, innovation, trustworthy AI applications, and etc. And for the law enforcement purposes, being implemented in FRTs or any other biometric data processing applications, in the beginning, for the law enforcement authorities, they should have acquired judicial protection, judicial authorization for using these systems. But now in the final AI Act, so the one that is accepted, we can see that this judicial protection was switched to the administrative authorization. That is for me interesting, because in this case, it's a little bit lower protection over public interest. We will see, of course, during implementation. So it's just a kind of foresight from me, but we will see in the end. Also, for the purpose limitation, once again, and for all these exemptional cases, I don't really see the logic in between classifying post-remote, real-time, remote biometric systems, because just because 5 days or 5 minutes later our data is being processed by these AI systems, it doesn't really show me any evidence that there is less risk or higher risk, or the risk is mitigated because post-remote is better than the real-time biometric system. So I can't really see the logic in this case in the AI Act, but as I said, we will see in the implementation. So finally, or no, before the final point, I was talking about the system accuracy issues and actually data accuracy issues in the GDPR. And in the AI Act, we have a very similar, actually bridging in between data accuracy and system accuracy issues, that actually AI Act ask for the providers to explain the accuracy levels to the deployer, that how they are being used, and how the data is being acquired, how it's being tested, and etc. But in the AI Act, it says actually the providers should disclose the metrics to the deployers, so not to the public. In my opinion, it would be very useful to also explain to the public what kind of accuracy levels are, or level actually, because in this AI Act, I can see that the lawmaker imagines there is one type of system accuracy level for forever, but specific to the technology, the accuracy level should be changed, especially, for example, as I was trying to explain, for the FRT accuracy level and the other system accuracy level shouldn't be the same, especially if we are talking about predictive policing. I don't think that it's same to classify the person with 90% confident level of criminal or 60% of confident level as criminal. Might sound a little bit sci-fi again, but why not? Why not to think before? Because we really should be acting before. So I really believe that the law shouldn't be running or try to run after technology, but it should be maybe going on hand by hand. So another criticism that I was taking in my article is that who is really deciding on the system accuracy levels, referring back to the predictive policing examples. If so, is it the system developer? So in this case, is it the provider, or there should be also a kind of input from the deployer? The AI Act is not clear from this sense, and my solution would be, in practice, is that the deployer and provider should decide together, and there shouldn't be a fixed level of accuracy level in this sense, because, as I said, purpose by purpose, the accuracy level is different and it means something, even if we are talking about numbers. So finally, and this system accuracy level question, the AI Act says that the Commission should actually reach a consensus on methodologies for accuracy measurement tools. It sounds strange to me. I have no further input about this concept, but I still wanted to write it in my article because I really would like to draw readers' attention to the fact that there is such a concept. I mean, how a commission as a political entity will decide about or find out about the accuracy measurement tools for AI systems specific to the member states, it will be quite challenging. I think these tools are actually being identified by the Commission for example, if I remember well, for food safety. But food safety and AI applications, they are not the same. So we will see how it will be in practice. That's also something that I really would like to see in the future. As far as I consider my analysis, summary of my analysis was clear to you. And in the end, I propose a solution of the data protection impact assessment to be enlarged to technology-specific risks. And I have some nice tables that the reader can see what kind of questions I would embed into the data protection impact assessments in order to highlight facial recognition technology specific risks. So this was all about what I wrote in my article. And for me, it's not really clear that the FRTs can enhance public trust, public safety or public security, but still these technologies are current. They are being implemented and they will be implemented in the future as well. Consciously or unconsciously, we will see. And for me, the most important thing is the transparency, because in one of the resources that I used in my referred in my article also says that if public is being communicated with the information that is understandable to them, because this term understandable is also a kind of important concept for me, then they have more tendency to trust in the technologies that is being operated under law enforcement authorities. It is actually true. I can also imagine that if I receive enough information, for example, in healthcare. Now, in the healthcare, there are many AI applications, and I'm aware that there are solutions that can explain itself, the AI system explain itself, how the output was reached to the doctors first, and the doctors can really interpret that information to the patient. So in order to ensure smooth communication, there are some solutions in some institutes, in some academics, in some literature as well. So it is possible to do so. And I just would like to highlight in this article as well, communication, transparency, explainability, they are still hot topics, and it should be further improved in a sense that can be also integrated to the AI Act's Article 4 AI literacy principle. So this was my all talk today, summary today about my articles. I'm very happy to receive any question, comments, feedback, anything else. Thank you.
So Gizem, then let me just ask a few questions here, if I may. So the first one, in my view, most important one is already about the very first idea that you have, which is that such systems are justifiable if they increase trust in a society or in a legislative system. I'm not really sure whether this is the main motive of states or of police authorities to introduce such a system. One might also be of the opinion that the main purpose of such a system is simply to keep the population under control in a proper way. So I would very much appreciate if you could at least a little deepen this argument for me in order to understand it better. And there's a second argument which is connected with this one. If I understand you correctly, one of the points that you are making, in particular in the GDPR part, is that a lot of this is undertaken by private companies, which is the very reason why GDPR is so much in focus here. So wouldn't it be then more of a consequence that if it's a state-driven goal, whatever that might be, trust, control, whatsoever, we need to reduce the probability and the amount of private companies the probability that there are private companies and the power those private companies have in this field for at the very beginning before discussing anything else. What would you say on that?
I'd like to start with highlighting to the second question, actually answering to the second question. Further even, I would like to really boldly highlight is that these kind of applications actually are not even placed in the EU. So it's not being trained by the EU companies, even by the EU citizens' data. Somewhere in other part of the world, as the clear view AI example of mine was very current in this sense. It's an American company. Of course, I don't really want to discriminate against any company to any other one, but even if we are talking about law enforcement authorities, let's say in some cities there are districts that are specific to some other cultures, some other ethnicity, some other behaviors, some other customs even. So if we start implementing these technologies in a general level, so without localizing them, it will be even more problematic in this sense. I think that train has already gone, that I don't think that any of the law enforcement authority has enough data to train their own systems, AI systems, whether it is FRT, whether it is anything else, whether predictive policing or anything else. They are dependent on the private companies to have to receive this data. But on the other hand, the good thing is that I don't think that law enforcement authorities have lost their mind that much. They also have to give away that the data they have in their hands. In this case, maybe they can limit access of the private companies to their data, or in another sense, they can have very strict rules for the companies to use this data. I don't know how much it can be practical or being implementable in this sense. But I think in this case, they are in a kind of equal power. For the citizens or for the public point of view, my true concern is that we are not really considered whenever there is an implementation like that. Like, do we really need these kind of implementations in this society? So nobody really asks our opinion, and some of the literature pieces that I was reading is all based on surveys to measure public trust towards law enforcement authorities, any technology used in this case, like body-worn cameras. You can see some examples in the literature, or CCTV, or any other kind of technology. So asking to the public via surveys, for me, is not very practicable in the 21st century. And even if the citizens' opinions are being asked, I'm not really sure whether the law enforcement authorities will really care about it. And at the end of the day, yes, I already have a chapter in my article. It is the law enforcement authorities that will be benefiting from such applications, because it is cheaper for them, less power to reach a decision or an output without considering the consequences. So that was the main idea in my article, that it's not that easy to just buying such a or hiring as a service of such AI implementations and just being used. Yes, I do agree with you that the law enforcement authorities don't really care about it, but if we are more and more literate in this case, maybe we can say no, or we can say stop for such implementations in a even broader manner. I don't really support also the social scoring or even credit scoring applications. So I also, of course, do trust to technology, and I'm very well aware of its potential, its capabilities, its inputs that they can give us and feed us back, but very being cautious and not at least putting them under our very fundamental rights level. Without all these explainability tools that are not yet available in the law enforcement, at least I'm not really defending the idea that if they can explain us why they are using, yes, we should accept it and adopt it forever. Actually, in the literature, again, based on some survey results, people don't really trust in law enforcement authorities, even if they give them some explanation, because that thin line between the purpose A and purpose many is fadeable with the help of the technology. So yes, I do agree with you in this sense. More literacy, I was just referring to how it could be. I'm just aware actually that in Finland, some of the schools, not all the schools actually, at the primary school level, as far as I remember, they started to teach AI technologies, so how they can be literate, how they can really interpret the technology, what is this technology about, what should they know, that the children and teenagers are being informed about AI systems. So without asking for any EU level official or any body to, bring up such ideas, some of the countries can implement very nice practices, some very nice course contents as well. And we as people should be really forcing our governments, our states, our authorities to introduce some such practicable solutions in this sense.
Yeah. Let me, if I may, just continue with a similar question here, which is one of the suggestions that you are making and that you were also presenting here is that we should enhance the role of data protection and fundamental rights impact assessments, legitimate use of these systems. My question to you now here is, if police authorities do not really care about our fundamental rights, and if we as citizens are not really asked that intensely, why should then such an impact assessment change anything, but apart from just being another piece of paper that needs to be filled out?
Actually, you are right. I've seen Metropolitan Police Constabulary's impact assessment, and they could even win the ICO's trust that they can run real-time biometric processing data in their area. But I still do believe that there are some good Samaritans in the society who really do care about these impact assessments. At least how much we are impacted, we can see maybe how much our fundamental rights are being impacted, and we can see the consequences in advance as individuals. So we can be really informed in the sense that, of course, we can also discuss about how much efficiently these impact assessments are being conducted, but still it's in law, it's a requirement. And I do believe that impact assessments together with AI literacy and all the quality and risk management ideas that is embedded in the AI Act are interacting together. So at the end of these interactions, I'm sure there will be something positive in this sense.
Okay, so let's hope that you are right in this optimism. I'm personally not that optimistic, but let's see. May I ask you one more question, Gizem, which is about Article 5, letter H of the AI regulation, which is the one, letter 5, just for those of you who don't do this on a daily basis. This is the prohibited AI practices, and letter H is somehow about what we are talking about here, although the terms are very funny. One of the funny details here, for example, is that real time is put into quotation marks, and I don't know whether this is to be ironic or whether the legislator tells us here that we don't really need to be that specific about real time, whatever. So this is somehow dealing with what we are talking about here. And as you know, I just want to confront our audience with this. There is an exception from this, or a list of exceptions, and this is the sheer amount of text here. So all this is about the interpretation of Article 5, letter H, on real-time biometric video surveillance. So my question to you now, I mean, you were quite clear, Gizem, in criticizing somehow the history behind this and how this made its way through into the law. My question now to you would be to really drill it down now, whether you think that fundamental rights impact assessments, data protection impact assessments, blah, 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 in combination with this sheer amount of more than 950 words, trying to make it clear under which conditions exceptions from this general rule that they should not be used are needed, in how far this will ever limit any police authority in Europe, at least in the next years, until we have the very first decisions of the Court of Justice of the European Union to, in fact, introduce these systems just in the way they want them. So the question is there any reason for this, your optimism, apart from being an optimistic person? And a second question that's a very tricky question is, would you buy an argument that for the probably negative answer to the first of my questions, there is an indication that Article 5, as it stands at the moment, is violating the Charter and is illegal as it stands? Would you go that far?
I won't really keep my optimism in this sense, being very optimistic in this case doesn't really help. Law is law. The sentences are there. The articles are there. It's already actually a very big exemption for the law enforcement authorities. We already know even the law enforcement directive is not really pretending like it reached its target. And we already know that we are all witness of the GDPR. We are still talking and discussing about what personal data is. Come on.
Mm-hmm.
Whether an output of an algorithm can be personal data or not. I already knew it like 6 years ago that of course it is, because it
Mm-hmm.
is. And yes, sitting and waiting for the first decision will for sure violate the fundamental rights. And it is, yes, of course, against the Charter. So most of the human rights organizations also, this was one of the hottest debated topic in the making of AI Act, actually, by the human rights organization, by some of the political parties in the European Parliament, that we should ban these biometric remote access or whatever, real-time, post-time. You see all those terms. It is just, I think, complicating the issue even more. So I don't really think that it is. I can't be really optimistic when we are talking about the legal part of it. It is paving the way for law enforcement authorities actually to do whatever they want, and to justify whatever they do is something applicable in law. And yes, I do believe that it is also against the Charter of the fundamental rights, right to privacy, starting from the right to privacy and some of the political rights that I was just referring to. But we will see how the board will approach to the guidelines and some other implementative documentation. It's actually a very tough task what the boards and what the national authorities will have. I'm just really sticking to the fact that the technology in this sense is not that far and not that well developed. Even though in the UK, even though in Germany, even though in France, there are some implementations. But I think the first blown in the volcano will be at the member state level, because I don't really think that in the member state level there is such a law that is broadly giving access to such data, broadly giving chances for the law enforcement authorities to process the data as they wish. So I think the first problem will be happening in the national level if there are such entire level of FRT's usage. Even though the EU law says so, it doesn't mean that the member states' national legislation is also that much liberal in this sense.
Yeah, which brings me to my very final question, if I may, for the moment at least, Gizem, which would be, what should we do as academics then? Is it sufficient to write interesting papers, or is there anything we should do on top of this?
I do believe that practicing is much more important than writing. So we should be practicing, we should be fulfilling our duty to inform public as much as we can. I'm starting with my own circle of people, individuals, as much as I can reach, my students here, my colleagues here, that I'm trying to, find some more practical solutions. Because as I said in the last 2-3 minutes of my unheard speech, that there are some tools that are enhancing explainability, transparency to doctor-patient relationship. For example, if the doctor is using some AI applications, then these AI applications, some of them are coming up with some ideas that the outputs can be explainable to the doctors with the reasons. And I think it is the academia, the scientific academia, the technical academia, who is coming up with such solutions. And how much it will be in practice real, we will see. But without doing this, I'm afraid I will lose my optimism. And I don't really want to, fall into this dystopian world.
None of us wants this, I think. And I'm also optimistic, Gizem, that your part was heard. So I don't think that we lost anything here, but I will check right after this conversation. For the moment, for me, this was very clear and very much to the point. Is there anything that you would like to add on top?
Thank you so much once again for spending your 50 minutes with me. And thanks for inviting me. I really also thank you that you helped me to fulfill my right to inform duty. I will continue working on this topic, and I will be focusing on the AI literacy, how it will be or it won't be in practical sense implemented. And I will also
Which is a
put
very
my own.
urgent topic because it will need to be solved until February 2025. So this is tomorrow, literally. And I don't see too many people having a clue at the moment what this Article 4 really means. It's weird, isn't it?
It is very weird. There's just an explanation. And what I understand as literacy as an information professional, first of all, because I have a BA degree in information management, and we really held this topic in entire BA level. We learned about what is literacy, what is information literacy, what is technology literacy. And I'm really, really curious how ethically we can really ensure AI literacy. If not ethically, then how legally and how practically it will be possible, and how technically it will be possible. Very, very interesting topic. So this is my future research topic.
Yeah, I congratulate you for this topic, and I think it's very, very relevant at the moment because everyone is searching for answers and nobody really has any. If I may, I will invite you again then, Gizem, whenever you're ready with the outcomes of your research, and then let's discuss AI literacy then a little bit more in detail if you agree. For today, thank you so much for joining us. My apologies again for the technical glitch in the middle. I hope that we solved it. Thank you so much again to all of you who listened to this, despite of the technological glitch. I do hope that all of you have a nice Christmas. There is another episode happening tomorrow morning, so it's not the very last one in this year. But however, if you don't watch it tomorrow, have a wonderful Christmas break. A happy new year, and take care of you. I hope that all of us stay as healthy as possible or become as healthy as possible very quickly. All the best. Thank you very much. Have a good time. Bye-bye.
Thank you. Bye.